Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. The information that I'm about to provide is based on current California law. It's general information and not specific legal advice. Today, I'll continue to talk with you a bit about your heirs. Your heirs are the people who will receive your assets when you die if you don't do anything to specify the people to receive them at your death. This is the fourth video in an 8-part series of videos. There are many ways to specify the people to receive your assets after your death, and we'll discuss those in a later video. In this video and in the next video, we will discuss the people who may receive your assets if you're widowed at death, meaning that you're no longer married because your spouse died before you. The relatives of your deceased spouse may receive some of your assets if you die not married, if you die with your most recent marriage having ended by the death of your spouse, and if you die having no living children or grandchildren. So the relatives of your deceased spouse, if they do receive anything, they'll receive only the portion of your assets that are attributable to your deceased spouse. And attributable to we'll define here in this video. Because there's no current marriage, there's no distinction of assets as community property or quasi-community property or separate property as of the death of the surviving spouse. But this distinction is important when determining the portion of the assets of the surviving spouse that are attributable to the deceased spouse. And the portion of the surviving spouse's assets that are attributable to the deceased spouse are half of the community property assets at the death of the surviving spouse that existed when the deceased spouse died. In other words, that's conceptually the surviving spouse's half of the community property as of the death of the deceased spouse. That's one. Two, half of the community property assets that existed when the deceased spouse died that the surviving spouse received from the deceased spouse, either by gift or inheritance. So in other words, conceptually, that's part of the deceased spouse's half of the community property that the deceased spouse gave to the surviving spouse, either during life or at death. Also, the total value of all community property that existed at the deceased spouse's death, that the deceased spouse had the power to control at death, and that the surviving spouse received at death automatically based on the death of the surviving spouse. Conceptually, those are assets that the deceased spouse owned, but the surviving spouse received either because the surviving spouse also owned them at the same time, or because the surviving spouse was the death beneficiary designated to receive those assets when the deceased spouse died. All three of those foregoing types of assets are applicable both to community property and quasi-community property. And the second and third of those are applied to separate property of the deceased spouse, not just to community, quasi-community property, but to separate property as well. Planning ahead for transfer of assets after your death can be very complicated. There are many factors to consider, including who you want to receive the assets. Also, consider how easy you want to make things for your relatives after you pass away. If you don't do this correctly, then you may create confusion and even conflict among family members after your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets after death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning, or even if you just have a question, please contact us and let us take care of you.